Thanks so much, Leah. And thanks for setting the stage. And thanks, Jan, for that wonderful introduction to your book. Systems dispute design is extremely important. And I think where we are today with this keynote is just to say what India is trying to do. India is actually at the cusp of an ODR revolution. And when I mean revolution, it is a revolution in the true sense. We've seen this for the last 20 years on what has happened all across the globe. But what is about to happen in India can set an example for the rest of the globe to follow. Many initiatives are currently underway to mainstream ODR in India and create a pan-India ODR ecosystem. This is being led by Niti Aayog and the Reserve Bank of India. The Reserve Bank of India has announced that ODR should be available for all digital payments. One of the most important statements on how they envision ODR to work for disputes is, quote, recourse to technology-driven redressal mechanisms that are rule-based, transparent, and involve minimum or no manual intervention is necessary to deal with them in a timely and effective manner, unquote. I think that is a very powerful statement. The real potential of ODR is about to be unleashed, and we are all excited to see the first implementation to be rolled out soon of this program in India. Now, the other major initiative is led by Niti Aayog. Niti Aayog, or the National Institution for Transforming India, is the Government of India's premier policy think tank, providing both directional and policy inputs. While designing strategic and long-term policies and programs for the Government of India, Niti Aayog also provides relevant technical advice to the center and states. The governing council of Niti, with the Prime Minister as its chairman, comprises chief ministers of all states and lieutenant governors of union territories. Niti Aayog acts as the quintessential platform of the Government of India to bring states to act together in national interest and thereby fosters cooperative federalism. Niti Aayog is releasing a pan-India ODR policy framework. We shall hear all about it from our panelists who were responsible for putting this together. Let me state that this was not an easy task. Multiple stakeholders like the government, judiciary, ministries, and industries were looped in to make sure there is acceptance and this works for all. Another important aspect I would like to highlight here is that the true sense of ODR is what the policy framework intends to achieve. Innovative technology to aid in all disputes, pre and post, with a focus on transforming the way access to justice or resolution is delivered. Now I'd like to introduce our panelists for today. Mr. Amitabh Kant, who is our first speaker and who would be delivering his address via a video recording, is currently the CEO of Niti Aayog. A 1980 batch Indian Administrative Service Officer of the Kerala cadre, he has been a key driver of initiatives like Make in India, Startup India, Incredible India, and God's Own Country that have positioned India as a leading manufacturing and tourism destination. These campaigns have won several international awards and embraced a host of activities, infrastructure development, product enhancement, private-public partnership, and positioning and branding based on extensive market research. In his capacity as Secretary, Industries, Government of India, Mr. Khan drove the ease of doing business initiative and ranking of states on outcome parameters. He is also the author of Incredible India 2.0, Synergies for Growth and Governance, Branding India, An Incredible Story, and the editor of The Path Ahead, Transformative Ideas for India. He is a member of the ODR committee constituted by Niti Aayog. The next speaker is Desh Gaurav Sekri, who is here with us. He is the Officer on Special Duty Law, Niti Aayog, where he heads the Access to Justice vertical. Prior to his time at Niti Aayog, Sekri established and headed the sports law practice at J. Sagar Associates from 2009 to 16, where he also specialized on governance matters. He is the author of Not Out, The Incredible Story of the Indian Premier League, published by Penguin India, and is regular columnist in national dailies. He a dual qualified lawyer. Sekri is licensed to practice in New York and India. He is a convener of the ODR committee constituted by Niti Aayog. We also have with us Deepika Kinhal, who is a senior resident fellow at Vidhi Center for Legal Policy and leads its judicial reforms team. She's currently managing multiple projects at the intersection of law and policy with other disciplines such as technology, design, and management to explore solutions to the perennial problems affecting Indian judiciary. In the recent past, she has worked as a part of the Supreme Court of India's E-Committee to envision Phase 3 of E-Court's project and assisted the expert committee set up by Niti Aayog on mainstreaming ODR in India. She regularly writes in leading print and online media on issues concerning the judiciary and women and child rights. Let us now hear from all our three panelists. Over to you, Colin, to show the video first.
Good evening, ladies and gentlemen. It is an absolute pleasure to speak before all of you distinguished people from across the world tonight on a major policy initiative by the National Institution for Transforming India on online dispute resolution. Let me start by congratulating the National Center for Technology and Dispute Resolution for organizing the 2021 Online ODR Forum. Given how well versed today's audience is with the concept and merits of online dispute resolution, my approach today will focus entirely on contextualizing the widespread scaling of this mechanism as a major policy initiative. Online dispute resolution in India has immense potential for solving disputes outside of the formal court system in an affordable and quick way. The COVID-19 pandemic altered how we function, and while it is a great challenge, it is equally important that we use this as an opportunity, one that helps alleviate the challenges faced by the most vulnerable of its overarching impact. One of the most encouraging developments recently is just how progressive and in fact innovative the Supreme Court of India has been in adopting technology. Indian courts today are quickly adopting leading practices in a sustainable and forward-thinking manner. I'm confident that we are witnessing a visionary period in the history of India's court system. The pandemic has forced a shift towards solutions that minimize contact and can be activated through technology, including for resolution of disputes. Progressive and disruptive changes in justice delivery are critical components that can alter the course of access to justice in an unprecedented way. Each arm of the Indian system is working towards a solution-driven future, and that is where behavioral change is most visible. Advancement of transformative technologies like artificial intelligence, big data, machine learning, and blockchain can be increasingly embedded in legal processes. Honorable Justice D.Y. Chandrachud, who leads the E-Court initiative of the Supreme Court of India, has on several occasions positively spoken about ODR and how it could be a vital cog in combating the clogging of courts. Under his leadership, critical changes are already noticeable, such as introducing e-filing of cases from anywhere in India, making it available 24/7, which is nothing short of a game changer. Indian courts today are quickly adopting leading practices in a very forward-thinking manner. A quote from one of his addresses has resonated since I heard it, that we must, and I quote, that we must look upon justicing not just as a sovereign function, but in the world of technology as a service which is provided to the community, unquote. Niti Aayog, seeing the potential of online dispute resolution as a first opportunity to provide access to justice, has taken the lead in formulating an action plan for online dispute resolution in India. In this context, Niti Aayog established a committee chaired by Justice A.K. Sikri, retired, to formulate an action plan for online dispute resolution in India. Members of the committee included several of the most senior bureaucrats of the Government of India. Though the committee's online dispute resolution report and further actions, our hope is that we put in place an action plan that not only enables it as an actionable framework now, but also one that adapts and endures the test of time for it to become an option of first recourse for several categories of claims in a dynamic fashion. This committee has tasked itself with creating a framework for technology-led dispute resolution, which assists the formal court system and lays the groundwork for a scalable and adoptable mechanism that stands the test of demand and time requirements. We have several actionable outcomes based on this report, and we will take forward with stakeholder support and participation. These are truly exciting times for technology towards access to justice and justice delivery. Ladies and gentlemen, online dispute resolution in India is at a pivotal cusp. A collaborative mechanism provides the potential to resolve a substantial percentage of disputes at the site of their occurrence without burdening the court. I'm happy to note that the report has been extremely well received by the stakeholder ecosystem, not only in India, but by international experts, many of whom are in this distinguished audience today. The report is the outcome of very extensive and diverse stakeholder participation. A robust ODR ecosystem in India will have high potential to reduce the load on courts by resolving high volume of disputes outside the court. And secondly, allowing gaining access to justice and ease of doing business by making dispute resolution cheaper, quicker, and most importantly, equally credible as conventional methods. The government of India has been working relentlessly to advance ease of doing business and ease of living. Online dispute resolution is at the focal point of these two missions. Going forward, Niti Aayog, in collaboration with the line ministries, civil society organizations, policy think tanks, industry representatives, and of course, international expert organizations like ICODR, will continue to work on ODR from an awareness and capacity building perspective. I'm delighted that today's event showcases the work in online dispute resolution as a collaborative exercise and sets into motion the use of technology towards efficient and affordable access to justice in our post-pandemic response. The support of the global dispute resolution community is appreciated and will be constantly called upon during our rolling out online dispute resolution as a viable multifaceted dispute resolution module in this new normal. I'm glad also to see that the work we are doing in India is being recognized across the world. This will only encourage us more to do the best we can to broad-base online dispute resolution. Thank you very much, ladies and gentlemen. It's been a real delight to participate.
Thank you, Mr. Kant. You are not here with us today, but I'm sure that you will be here, you will be with us at our, physical conference, probably later this year in Dublin or next year, perhaps in Tokyo. And really looking forward to that. That was such a powerful address. And I think all my colleagues out here from the National Center for Technology and Dispute Resolution, as well as people in the field of online dispute resolution, can see why I term this as an ODR revolution. Because, everyone is taking it really seriously. And the true sense of online dispute resolution, of introducing artificial intelligence, data, bringing it to the people, access to justice, leveraging technology, justice as a service, all that is coming to force really soon. Now, I'll hand that over to, I think who's going to be talking next, Deepika or Desh?
Deepika.
I'll be taking over from here.
Okay, so over to Deepika, who has helped, as I, introduced her. I think, she will now talk about how this framework came into place.
Thank you, Chitu. It's a real pleasure to be here. I'm in fact very humbled to be a part of this gathering. Let me take a second to share my screen. Oops. I hope this is visible.
Yeah, you're good, Deepika.
Yes. So I will take a few minutes to take us through the developments that ultimately culminated in the constitution of the committee itself. This would give us a glimpse of why we are even considering ODR in India and what were the various issues that were before the committee while it kickstarted its work. I think the figures on the screen are eye-popping and self-explanatory. Whoever is following the status of Indian judiciary will know the kind of backlog that it is burdened with. At the moment, across all 3 tiers of Indian judiciary, there are around 43 million cases pending. While that is a picture on one side of the equation, on the other side, we see that India is ranked 163rd in the overall enforcing of contracts indicator in World Bank's EODB rankings. So what we really see here is that on the one side, we really need to take measures to reduce the supply of cases into court system. At the same time, we need an avenue to effectively and efficiently resolve lakhs of disputes that arise on a yearly basis, especially those concerning businesses, essentially contractual disputes. Over the course of last couple of decades, quite a few solutions have been explored, including the ones within alternative dispute resolution framework. However, they haven't been very successful in catering to these twin requirements, which is reducing the supply of cases to courts and second, providing an avenue for effective resolution. And this is where ODR comes into picture as something that can augment the efforts that are already taking place through ADR or through tribunals, etc., as well as enhance opportunities otherwise through, further integration of technology. And here we, world is our oyster in terms of, what we can think about through smart resolution of disputes, automated resolution of disputes, smart negotiation tools, etc. So overall, given the status quo that is currently in place in India, we think that ODR could possibly be a way out of this messy situation we find ourselves in. So ODR is not something that we are grappling with only in recent times. We have Chitu with us, who is known as the mother of ODR, and she is from India. So it is not an entirely new topic for us. And this slide before us tells us how we have been sort of exploring the concept of ODR since early 2000s. 2006, we had a platform to resolve just the domain name disputes, but beyond that, it did not progress much. Then in 2011, we, a city in India, Chennai, we hosted the 10th Annual International Forum on ODR, and Chitu steered that entire event. While it did create some buzz, there was no large-scale adoption. And then you will see that there have been certain events dispersed over the course of last decade or so. But the real attention towards ODR started only over the course of last 3 to 4 years. And this we can see in the pileup of events in the last part of this slide, which is from early 2019 until 2020, there have been a lot of hectic activity in this entire ecosystem. This also has a lot to do with how overall the judicial system in India has been portrayed to be incapable of bearing the burden of a high supply of cases. So it was almost like the urgency of matters leading towards the entire ecosystem shifting its attention to ODR. And we see that happening through these back-to-back events. In fact, in February 2019, there was an EADR challenge, which garnered a lot of attention. And since then, we see a lot of activity in the private sector, especially with multiple startups catering to a wide variety of disputes. And then in February 2020, we see that the government of India itself launched an ODR scheme for resolution of tax disputes. And most hearteningly, in 2020, as you can see this as a response to the COVID-19 situation, the judiciary started embracing ODR, and that was a big momentum towards ODR, because once we have judiciary's vote of trust towards the mechanism of ODR and ODR outcomes, it enables the entire ecosystem to move towards ODR with greater confidence. So over the course of last 3 years, what we see is that the government is supporting ODR, the private ecosystem has started providing ODR services, and lastly, the judiciary has come on board in full effect. And this is the trend we see in India at the moment. And this is based on our study of what has happened across different jurisdictions, is similar to what is happening there. That we have certain government-run ODR initiatives, we have court-annexed ODR initiatives, and then we have private ODR platforms. I will take a couple of moments to give you a glimpse of certain initiatives under each of these 3 categories, and then go on to identification of issues that arose through these recent developments, which ultimately led to the constitution of committee to address those issues. Because without such specific targeted group coming together to brainstorm and think about ODR, the issues would have remained as they are, and that would have proved to be a huge roadblock for widespread adoption of ODR in the country. So a couple of examples of government-run ODR initiatives. We have a portal which has been developed by the Department of Medium, Small Scale and Micro Enterprises. It's a portal that can be used by businesses to reach out to officials who have been designated as mediators. And these are officials within the department as well as those that have been onboarded as an external neutrals who have been onboarded onto the platform. And businesses have been resolving disputes through this Samadhan portal developed by the government. The second is the integrated consumer grievance redressal mechanism. This is a recent development basis certain amendments that were brought about to the consumer protection framework in the country. So at the moment, not only are we seeing developments in terms of mandatory mediation or pre-litigation mediation for certain categories of cases, and that category does include consumer disputes, we are also parallelly seeing a push towards integration of technology while providing those mediation services. And this is part of government-run initiatives. The second is court-annexed ODR centers. Here we are talking about mediation and arbitration centers that are attached to courts who with integration of technology are moving towards providing ODR services. This again, the 2 items that I've listed over here are developments that happened during the course of the lockdown period. So clearly there was no other avenue to provide justice but to go the technology route. So the first is the online mediation project, which was attached to the Delhi High Court. Samadhan, so Samadhan, as you can see, is a very popular phrase. It translates to resolution. So Samadhan online mediation project was initiated by Delhi High Court to offer e-mediation services. Then the biggest development in terms of number is what happened during e-Lok Adalats. So Lok Adalat is a form of alternative dispute resolution mechanism provided for in the Indian legal framework, which is run by courts. So the courts themselves identify a large category of disputes that can be resolved through mediation. And e-Lok Adalat is a subset of it, in the sense that these are Lok Adalats that were conducted entirely online through a technology platform. And through this, lakhs of disputes were resolved, not just in urban areas, but also in rural areas and tier 2, tier 3 cities, where typically the challenge of digital penetration exists. So with e-Lok Adalats, proof of concept of large-scale ODR was presented for the Indian ecosystem. The last is the private ODR service providers. As I told you, over the course of last 2 years, we have seen more than a dozen odd startups beginning to offer ODR services. We see broadly two trends emerging here. These startups either provide end-to-end services or provide standalone technology platforms. And they have been providing arbitration, mediation, and smart negotiation services at the moment. So we are seeing typically the first phase of ODR kickstart in India. And at least to my knowledge, we haven't gone to the second phase or the more advanced phase where we are talking about automated dispute resolutions, intelligent dispute support systems, etc. And the fourth point, which is important, is the categories of disputes that are being resolved currently through these private service providers. We are looking at banking sector disputes, consumer disputes, commercial contracts overall, and family disputes are beginning to be streamed directly through the ODR platforms and are actually getting avoided from getting stuck in courts. So through these various developments and during our course, during our interactions with all three categories of ODR service providers, we were able to identify that there were a lot of roadblocks that needed to be overcome for ODR to be truly mainstreamed across various dispute categories and to become a first resort for resolution of disputes. The first bucket here is a few structural challenges that that are sort of typical to what India as a country is. So there is a huge digital divide. In urban India, you will see, internet being used by everyone and access to digital infrastructure being quite robust. But if you look at rural India, it is still lagging behind over there. So that is a huge challenge that we need to consider when we talk of, mainstreaming ODR in India. Then there is a problem of digital literacy across a huge section of our population. Then we have divide in access to technology. And of course, Indian laws themselves are sort of stuck with archaic legal processes that will need to be changed to truly benefit from integration of technology into dispute resolution processes. Next, we identified a few behavioral challenges because anything to do with technology in India and elsewhere is met with a lot of resistance and a lot of mistrust. So how do we overcome this barrier to ensure that ODR is adopted at a large scale? Second is the legal culture. So here we do have the culture of going to court as a first resort, and typically lawyers themselves are very skeptical of anything outside of the judicial system. So the challenge was about onboarding lawyers as adopters of ODR and as people who will popularize ODR amongst disputing parties. The third is ODR for government disputes. And this again is a very typical Indian problem because we have government as the biggest litigator in the country. A conservative estimate shows that around 46% of disputes pending in the country have government as a party in various shape and form. So how do we enable government to adopt ODR, which will essentially solve at least one side of the problem, which is clogging of Indian courts? And the third bucket of concerns is regarding the concerns of end users, which is extremely important to build trust in ODR and ensure that it is something that is voluntarily adopted and not something because a policy or a law mandates it. And these are the concerns that I heard speakers yesterday talk about extensively. So I'll just list it out. Privacy and confidentiality of data, transparency and accountability of ODR service providers, especially the private sector providers, availability of neutrals. For example, if we do mandate ODR, if ODR becomes the first resort, how do we ensure that neutrals, quality neutrals are available to provide those services? And fourth is enforcement of ODR outcomes, which is a huge challenge. It is an actual roadblock as well as a mental block for anyone who is attempting something outside of the court system. So these were the overall set of challenges that were before the committee to try and overcome through extensive consultations and through research. And that is what the committee took on when it started its work in July 2020. With this, I'll hand it over to Desh to go into the details of committee's work.
Thanks, Ritika. I think you've made my life very, very easy. So with Mr. Khan setting the context and providing a macro outlook to how India approached, or at least Niti Aayog on behalf of the government of India approached the ODR policy framework, and with the extent and depth of the work that Deepika and her team had already done entering July 2020, I think it basically became more of a process issue for us and a consultative, inclusive process where we took a lot of the knowledge that already exists and tailored it for the government of India from their perspective and from the perspective of how best it could be rolled out in India in its most expeditious and inclusive manner. So I'll just quickly share my screen. And is this visible?
Yes,
Yeah.
Desh.
Okay. So what I'll do is I'll start immediately with the composition of the committee. The committee, as Deepika mentioned, was constituted in July 2020 on the back of what had been several productive conversations that we had had with members of the judiciary, both current and former, as well as industry stakeholders. We got a good sense of the repository of startups in the ecosystem, as well as all the policy work that had been done. So July 2020 was a good time for us to take the next step from the Niti Aayog's perspective. So the committee was set up with a retired Supreme Court judge, Justice A.K. Sikri, who is who's known to be one of the most progressive and technology savvy former Supreme Court judges. He was the chairperson of this committee. The CEO Niti Aayog, whom you all heard a short while back, was a member of this committee. And then we took 6 of the most critical ministries and took their most senior bureaucrats, basically the secretary level representative from each of these ministries. And so the Ministry of Micro, Small and Medium Enterprises, the Department of Legal Affairs, the Department of Justice, the Department of Consumer Affairs, the example which Deepika in fact had just given in her presentation, the Department of Promotion of Industry and Internal Trade, and the Ministry of Corporate Affairs. These were the 6 secretaries who were representative of this committee. It was convened out of Niti Aayog, and the administrative secretariat was in fact established to provide both research and drafting assistance. And this is a gross understatement, because I think a lot of the fluidity, a lot of the efficiency with which we could get a report that actually took into account several of the global leading practices, it was done because we had a lot of the work being done in real time by Deepika and her team. The team consisted of Deepika, who you've just heard, and her team with Vedahi Mishra and Aditya Ranjan, and Satvik Mishra, who's from Niti Aayog. The terms of reference of this committee, so our overarching objective was to develop an action plan for ODR in India. The specific objectives started with identifying and amending the existing laws/regulations as well as rules to help enable ODR, an identification and facilitation of strategies to adopt ODR as a means of dispute resolution in the key and relevant sectors, analysis of the global best practices in ODR, specifically for dispute avoidance, containment, as well as resolution, to help recommend suitable models for justice delivery in the Indian context. And lastly, and this was in fact what we feel is the most critical component, was collaborating with the judiciary, industry, and the entire ecosystem to help ensure that the policy framework we were developing was one which took into account all the concerns, considerations, and opportunities for the entire Indian ecosystem. The consultative process, as Mr. Kant had alluded to and Deepika very briefly mentioned, it was a comprehensive exercise spread out over a period of nearly 3 months, where we sought written comments to curated questionnaires from the entire stakeholder group landscape, as well as the committee members, which was then followed by oral consultation sessions with, again, the stakeholder groups. And we also had a series of one-on-one conversations with leading experts with domain expertise, which was then followed with by consultations after the draft report had been shared in the public domain. So what we did is after we had drafted the first version of the draft report with the support of the committee members and all our initial conversations, we put it out in the public domain for public comments for a period of 2 weeks, where we also at the same time engaged with members of the judiciary and also had high-level conversations with domain experts to further improve and expand on the draft report as it stood. In total, we had 18 consultations that we organized with a total of 6 stakeholder groups and 12, sorry, that's a typo, but it should be 12 domain experts. We received 63 detailed written responses, which included representation from dispute resolution professionals, businesses, which have been the key drivers thus far of ODR in India, lawyers, dispute resolution centers, ODR startups. Deepika mentioned that there were a dozen. I think by the time from the time we started to the time we closed the drafting of the report, I think that number had gone up to approximately 19. Deepika will correct me if I'm wrong. And also what we did was, because last mile access to justice was so critical, we also included the rural ADR service providers. In total, we consulted approximately 85 people with certain repeat conversations that we've had in the last month as well. So taking that number up to approximately 100 in total. We had also engaged with a civil society called Civis, which further extended its outreach to all of the relevant sectors. And they then collated responses from 41 entities and individuals. Meanwhile, and this was a very, very important aspect for us, we had 2 extensive consultations with domain experts from India and especially with iCoder. So Colin, Chitu, Janet, Leah, and Ethan, we had a couple of long conversations with them, and that really helped set the context for us. And lastly, in addition to what we had done with our outreach, we also received 16 representations from several of the stakeholder community at my email address, and we took these into account as well when we were framing the report towards finalization. The report, given the sensitivity of some components of it, as well as with an approach to ensure that it had the maximum benefit to all the individuals who could potentially utilize and roll out ODR. We're in the process of finalizing the report, hopefully in the next couple of weeks. But what we're trying to do is, in part A, which is going to be a report that will eventually be in the public domain, we will provide an introduction to ODR, a background to the committee and how we went about the entire process. We're providing a cross-jurisdiction analysis, a present status of ODR in India, as Deepika had in fact walked everyone through just now, the challenges which are quite key, and the recommendations which I will just shortly walk you through very quickly. Part B, in fact, is where we looked to provide curated approach notes for each of the committee members and their respective departments or ministries, which would in fact lay out an action plan for ODR integration. Deepika had mentioned a very key statistic, which is that 46% of most litigations are or emanate from the government. So with using the government as a lighthouse sector for integration and rollout of ODR, and with the support that all of the departments and ministries were giving to ODR, we felt that this is a very, very efficient way of pointing out what the opportunities are for their particular departments or ministries to integrate ODR. Recommendations very briefly. So I know Deepika had mentioned the challenges, so I'll just quickly go through the recommendations. The increase in access to digital infrastructure was one of the primary components, where we have suggested an increase in physical access to digital infrastructure, along with that of digital literacy. The strengthening of existing and an increase in overall capacity, given that if ODR does roll out to the scale that we are envisioning it to, we would need a significantly expanded capacity base. So the upskilling and training of new professionals with uniform training standards was a critical aspect, along with the strengthening of the paralegal services within the relevant communities. The adoption of ODR platforms for specific government sectors, which again goes back to the government taking the lead, and also the strengthening of the court-annexed ADR centers, which could then harness the potential of artificial intelligence and machine learning. And lastly, with the fast-growing private sector capacity and an increasing number of neutrals available to be able to staff a lot of the matters, the resolution of COVID-19 induced disputes is a point of first contact in our opinion. Building trust in ODR with an ongoing awareness rollout plan as well is something that the committee and Niti Aayog are looking at very closely. So we have mentioned that ODR for the reduction of government litigation is a key aspect. At the same time, the running of a large-scale, comprehensive and coordinated awareness campaign of the benefits and efficacy of using ODR is something that we are looking at very closely, as well as the introduction of targeted incentives per stakeholder. The strengthening of the existing legislative framework, this is an ongoing aspect with the Mediation Act in the works, as well as introducing a regulatory framework for both mediation and data protection, along with the introduction of certain necessary amendments to key statutes in India. At the same time, we're looking at progressively mandating pre-litigation mediation for classes of cases. And this is where the collaboration with the judiciary is extremely important, and it has been extremely well received by the judiciary as well. So this is a very encouraging sign and shows us what the potential is of ODR from a court-annexed or pre-litigation mechanism framework. The digitizing of legal processes like stamping and notarization is another aspect that we have addressed in our report. And this was again based on extensive consultations with lawyers and dispute resolution professionals. From a regulation aspect, what we are looking to do is recommend a light touch approach, where we are working on voluntary principles for ODR platforms, ODR centers, and ODR neutral / mediators, and also to identify and introduce a SRO, or a self-regulatory organization, which will be composed of members from the ecosystem across the board, basically the entire life cycle of matters. They should be adequately represented within this SRO to ensure that the compliance of principles is established, maintained, and the credibility of the process is also ensured. And lastly, among the several ODR initiatives that we have recommended, the implementation should also be such that it is accomplished in a phased manner, so that it's sustainable and well thought out. So broadly, that was our approach, and also that's how we tackled not only the consultative process but the drafting of the report, and with the criticality of getting a representative recommendatory. So in terms of, we were not insular enough to think that we don't require the support of what is happening across the world. And we wanted to ensure that no member of the entire ecosystem was left out when we were consulting with them. So that's why we're quite confident that this report will take into consideration a lot of what we hope will be the future of ODR, or as Chittu said, the ODR revolution in India. And of course, I'll finish by once again pointing out that the extensive nature of the work that Deepika and her team had done really helped give us a holistic perspective on what the global best practices were, and made our lives a lot easier. So Deepika, good platform to thank you. So thank you. And if there are any questions, please, we'd be happy to answer those.
Yes, unfortunately, it looks like we might have lost Chitu, but I wanted to just say on her behalf, because I know she would say this as well, what an incredibly inspiring and impressive presentation from Deepika and Desh. It's amazing what is happening in India. I think this is the most sophisticated, well-conducted dispute system, online dispute resolution, dispute systems design exercise that's ever occurred. And I don't want to speak for everyone in the global ODR field, but it's humbling to see how seriously and the thoroughness with which this task has been undertaken in India. So thank you so much for sharing. And the world is watching. Not to put any more pressure on you than you might feel now. But let me just open it up for a minute or two and see, does anyone have any questions that they'd like to ask Desh or Deepika about everything that's going on in India? Please feel free to raise your hand or put something in the chat. Desh, I think it's very clear you've astounded everyone. They're stunned into silence by the scale.
Maybe,
please,
Colin,
Lorna.
maybe one question: is there an expected time frame, or is that still premature to think of when we'll actually see?
So the report itself is just going through the final approval processes. So we're not anticipating a period, and Deepika will bear with me when I say this, because we were ready for the rollout a couple of months ago. But what was important is that we made sure that the judiciary was also, and the e-courts committee was also on board with our suggestions. And Deepika, we're donning both hats, could understand where we had to make sure that we were taking everybody along. But our anticipation is that it shouldn't take more than a month or month and a half. Having said that, I don't want to jinx it, but sooner rather than later.
So Colin, this is Jaya Sharma, may I ask a question?
Please, Jaya.
So to my Indian colleagues, I know that in India, you don't have a special act that permits mediation. It's the 1996 Conciliation Act that allows mediations to be undertaken within the framework of an arbitral proceeding. So what I'd like to know is, if you do ODR on a large scale, would you have to bring about any kind of legislative changes to incorporate this into the Indian legislative framework?
Go ahead, Deepika.
That's actually a great question, Jaya, and that is one of the key concerns that we have tried to address in the report as well. So there are two aspects to it. One is the existing legal framework and whether that provides for ODR. The answer is yes. The problem, however, is that this provision for ODR is scattered across different legislations. As you rightly said, there is one legislation for arbitration and conciliation. We do not have a parent legislation for mediation yet. However, mediation is recognized as a part of conciliation, and it is also specifically recognized under the Civil Procedure Code, which governs all civil disputes in the country. So while there is recognition for all kinds of ADR mechanisms across different legislations in the country, we do not have a parent legislation for ADR and no parent legislation for mediation. So what we do suggest in the report is that we first amend the existing legislations. In the first phase, amend the legislations to specifically provide for technology integration into these ADR mechanisms. And in the second phase, which is likely to take more time, we provide for specific umbrella legislation for ODR. So that is how the report deals with it. But as things currently stand, there is no problem to undertake ODR processes in the country. It is perfectly legal.
So I think we have time for one last question. Mayur, I see your hands up.
Thank you very much. Interesting presentation. As you know, the Mediation Center has a contract with the LA Superior Court, which has about 80,000 cases a year that's filed. And it does have one of the largest integrated systems. There's about 650 courts, 550 judges, and we have a contract to do ODR. In fact, we got it in 2018, long before COVID was even thought of. And by foresight and forethinking, we've been using ODR, Zoom conferencing, since 2018. And we did get a contract, which is very extensive. And what the court decided to do was to outsource all mediation services. It used to run a program which was quite extensive with over 10,000 cases a year, but it changed that because of the budget cuts. So when it outsourced the program, the ODR program, we basically, they put all the burden, the financial burden, on the private sector to operate and run it. So we've been operating as a nonprofit. We're the only nonprofit that runs, has a contract with the court. The other two are proprietary. I just give you that background because my big question is how in India, who pays for the services of the private industry panels? Because in our case, they've left it to us to raise the money to provide either low cost or free mediations, and they've left it to us to charge the parties some small fee to access the quality mediator. Also, we have very high standards that the court imposed on us for our mediators, and it was up to us as private panels to vet all these standards, which was at least 10 years of good standing, 20 to 30 years of practice in the law, and at least 40 hours in more training and experience. So we have very high standards, but all of that was outsourced by the court to the private panels. I'm just curious, who pays for everything in India?
Great question. Desh, Deepika, who's going to foot the bill?
So that's a tricky, situation. In India, we haven't actually progressed so far as to actually identify who is going to pay the bills, who is going to fund this entire initiative. From our experience with the arbitration sector, what we've seen is a lot of private arbitration centers are functional. At the same time, there is a cap on arbitration fees, arbitrator fees provided for in the legislation. So that we know is proving to be problematic for the sector to thrive and to attract quality professionals. So arbitration bar is not yet a thing in India. To avoid similar, as in I can't say for sure which direction mediation will take, because as I said, we do not have an umbrella mediation legislation yet. So we will have to wait and watch if mediation legislation will also similarly prescribe a schedule for mediator fees. But we don't yet have clarity on that. The way it is currently structured, we have mediation centers attached to courts, which have very nominal fee, but that is applicable only for disputing parties who do refer their matters to these court annexed centers. The private mediation centers continue to exist, and there is no bar on the fees that can be charged.
Wonderful. Well, I would like to wrap it up there. I think we could easily talk about this for the rest of the day, but I think I want Deepika and Desh to hear from all of us in the global ODR community. We want to continue to be a resource. We're very excited about the work that you're doing. And if maybe all of us could join together and give a round of applause to our panelists for an excellent keynote presentation this morning.
Thank you. Pleasure to be here.
Yeah,
thank you so much. Please, Chitu.
It is really great to hear, I think, for the global community on what India is doing. And I think look out for more. We are going to have a page dedicated on iCoder just for India. You could see all the updates on what is happening with Niti Aayog. The draft policy will be out there. The articles about what's happening in India is out there. We will also put up, what's happening with the Reserve Bank of India. We're having an ODR handbook, which is coming out. That is also going to be up there. So please look out. Lots of things coming out from India. Thank you, everyone. Thanks so much, Tej. Thanks, Deepika. Thanks a lot to Mr. Kant for sending us that video recording, and hoping that we will all meet soon. Thank you.
And thank you as well to Chitu, the mother of ODR in India, for planting these seeds that are now growing into a forest. So wonderful, wonderful. What an excellent session.